Good morning, everyone. I'm Judge Jackie Powell, and we're in first appearance court this morning. Today is not your trial date. Today is the day that I'm going to tell you what you're being charged with. If I find probable cause, then we're going to determine release conditions. Today is not your trial, and I say that again because everything that is said in this courtroom is being recorded. So if your intent is to go to trial or to fight the charges at a later date, you may not want to say anything on the record before speaking with your attorney. In the courtroom today, I have an attorney from the State Attorney's Office, Mr. Eric Linder.
You also have your
Elizabeth Barrientos, Your Honor.
And good morning, Ms. Barrantes.
Barrientos.
Barrantos. We also have Ms. Barrantos from the State Attorney's Office. Also, we have an attorney from the Public Defender's Office, Mr. Brian Reedy. And we also have pretrial supervision, confinement status, the clerk's office, and our bailiff is in today. So when I call your name, I'm going to ask you to step up. Those of you at the main jail, there's an attorney there from the Public Defender's Office. If you are represented by him, he'll step up with you, or if there's anything that needs to be said. For those of you who have private attorneys, if your attorneys are in the courtroom, when I call your name, your attorney will also come up and speak on your behalf. And so this morning, I'm starting off with Michelle Morton.
No problem.
Okay. Ms. Morton, good morning. You're before the court today for an out-of-state felony hold. You should be going to extradition court next Tuesday or Thursday. Good luck, ma'am.
That's it?
That's it.
I'm going either next Tuesday or Thursday?
Yes, extradition court is Tuesday or Thursday. I don't know which docket you're going to be on.
Will it be here in Florida?
Yes.
Oh,
Okay.
I'm not going to New Jersey?
You're gonna go to court for them to tell you when you're gonna go to New Jersey, okay? Melinda Ventre? Melinda?
Not right, Your Honor.
Ms. Ventre, good morning.
Morning.
Ma'am, you're before the court today for a misdemeanor KPS. It's a trespassing matter. It's out of,
I had a conversation with Mr. Shate earlier today.
yes,
He cannot attend court this morning. He wants to know if the court could either, one, reset his matters for 1 o'clock this afternoon, or two, if the court's inclined to resolve them and the client wants to resolve them, he's not objecting to that either.
I'd like to read today, ma'am.
okay, Ms. Ventre. I guess you heard what the attorney said, that there's an attorney, Steve Shate, that represents the city defendants. He's not here today. We can reset this for the afternoon if you need more time to speak with him.
No, I would like to resolve it now, ma'am.
All right. Ms. Ventre, if you want to resolve your case, it's going to be an adjudication and time served.
Yes, ma'am.
All right, please raise your right hand. You swear or affirm to tell the truth?
Yes,
You
ma'am.
can put your hand down. Do you understand the proceedings that you're in today?
Yes, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Do you understand that you have the right to go to trial, that by taking a plea, you're giving up that right this morning?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that by taking a plea today, it could subject you to immigration changes or deportation hearings?
Yes, ma'am.
What plea do you wish to enter, Ms. Ventre?
No contest.
All right, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, ma'am, will be adjudication and time served. I'll give you 6 months to pay your court costs. Good luck.
Thank you.
All right, I'm gonna call from the sign-in sheet on page 22, Craig Fraser.
Good morning, Your Honor. Steve Melnick, on behalf of Mr. Frazier.
Good morning, Mr. Melnick.
Good morning. I got called from the office of.
I was gonna say.
Yes.
What's happening here?
We have a bond amount that the state and I agreed upon for the burglary of $7,500. Is that correct, Ms. State Attorney?
That's correct, Your Honor.
On count 1, 7,500?
And leave the count 2 at the 1,000.
Okay.
Mr. Frazier is currently being supervised by pretrial services in case number 18-10280 CF10A, 1 count of aggravated fleeing, 1 count of aggravated assault on law enforcement officer. Based on this court's finding of probable cause, I'm gonna ask that his pretrial status be revoked.
Your Honor, we'd ask that this be left up to the division and the judge. We have depositions on this matter set for the 19th of February, and that case is weak at best. So we'd like the division to make that decision whether, and let Judge Garcia Wood decide whether to revoke his bond or not.
When was he placed on pretrial?
I believe I wrote it there on the top.
It's about 8 months, Your Honor, he's been on with no violations.
I'm looking at it.
And the
He was
violation
placed
is,
on pretrial on October 2nd, 2018.
the violation is this?
Yes, ma'am.
No, sure. All right, then I won't revoke the pretrial at this time.
You will not, so you
I will
don't
not.
have to sign it.
Oh,
Okay,
I
thank
will-
you. And he keeps the GPS monitor
I will
on,
leave
correct,
that
Craig?
for-
You understand?
Judge Garcia Wood.
Nod your head.
Yes.
Okay, thank you, Your Honor.
I find probable cause as to both counts. Count 1, the bond is $7,500. And count 2, the bond is $1,000. Good luck, sir.
Thank you, Your Honor.
All right.
Thank you.
And then on page 4, Natalie Williams.
Good morning, Judge. How are you?
Good morning, Mr. Weeks. I'm well. Natalie Williams. Natalie Williams.
Judge, I think she's at North.
Good morning, Ms. Williams.
Morning.
Ma'am, you're before the court today for 1 count of robbery with a weapon, 2 aggravated battery causing bodily harm, and 3 kidnapping or committing to facilitate commission of a felony. The court does find probable cause as to all 3 counts.
Your Honor, the state, on count 1, well, I'm gonna be asking for no bond on count 1 and count 3. She was booked for robbery with a weapon on count 1. I would direct the court's attention to the probable cause affidavit. The charge that the detective put in was robbery with a deadly weapon. Sorry,
All right, okay, go ahead.
thank you, Judge.
Oh, when I turn the speakers off, can she hear? Okay. All right, please go ahead.
The weapon described in this case is a firearm. So I would be asking the court to make a finding for robbery with firearm / deadly weapon. It's all under the same subsection. Based on the probable cause affidavit, I'm seeking a finding of proof evident or presumption great on counts 1 and 3 for first appearance purposes only, Judge.
Mr. Weeks?
Judge, I'll stipulate for proof evident presumption grade in reference for first appearance only. I'm asking you to give her a bond on these counts. I know we're at first appearance court. I would indicate to you that she's been a lifelong Florida resident. She's lived in Broward County for a long time. Her place of birth is Fort Pierce. She has 2 kids, and she can afford somewhere between $50,000 to $100,000 bond. So I'd ask this court to allow her to bond out of these charges. I'm asking the court to give her anywhere between $100,000 to $50,000 bond on these counts, counts 1, 2, and 3. I don't believe she has any priors that Mr. Linder has indicated to me, or have I seen?
She has criminal history, nothing substantial. That being said, Your Honor, I think these facts, standing alone, warrant no bond hold, Your Honor. I'm concerned not only the level of violence that a firearm was allegedly used. It appears this was a planned act in that the victim was ultimately lured and then forcibly brought to a location where there were other co-defendants laying in wait that eventually attacked the victim, at which point he was robbed.
Okay, I have reviewed the probable cause affidavit, and I do find probable cause. I find probable cause as to count 1, robbery with a firearm. I'm also going to find that proof of guilt is evident, presumption great. There will be no bond on count 1 at this time, and no bond on count 3. As to count 2, I will impose a bond of $100,000. And just for your information, Ms. Williams, this is just first appearance, and so your attorney will tell you that you will have an opportunity to have an author hearing on the no bond holds. So this finding is without prejudice.
Judge, I indicated that to her on the phone earlier this morning, so I told her that I'll be getting a court date for her within the next 5 days.
Okay. I'm also going to advise Ms. Williams that she should have no contact with Roni Espinoza, and there are 2 co-arrestees, no contact with those 2 either.
Thank you very much.
Good luck.
Certain instructions. We'll talk about it after. Hey, so here's the deal.
Okay, on page 24, I have Nathaniel Ware. Sorry, you're a Spanish interpreter? Okay, one moment. Nathaniel Ware, 24, page 24, Nathaniel Ware.
Does the name sound familiar?
Mr. Ware, ma'am? Okay. Mr. Ware, you're before the court today for 1 count of possession with intent to sell, manufacture, or deliver cocaine. 2, operating without a valid driver's license. 3,
There's some people.
open container. That's not for magistrate. 4, improper stop. It's not for magistrate. And then 5, there is a felony violation of probation. I do find probable cause. Does the parties wish to be heard as to bond?
No, Your Honor, I checked. It appears the violation of probation is from another state. So at this point, BSO will, after today, will contact the Department of Corrections and have that state notified so they can prepare a warrant if they so choose.
Okay. All right, so counts 1 and 2, I do find probable cause, and then the violation of probation is for out of state. What does the parties wish to be heard as to the bond?
No, Your Honor.
Okay, all right. Then I'm, ladies, do either of you wish to address the court?
Yes, ma'am.
Can you please state, raise your right hand, ma'am. You swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. State your name.
Katrina Hall.
Katrina.
Hall, Hall.
And is there something you wanted to tell me in regards to the bonds? This is not his trial, so I don't want you to talk about the case. We're trying to determine bond, and I will take any information that you want to give me in regards to that.
Being that this just happened last night, ma'am, do I have the opportunity to obtain an attorney for him?
Yes, and there's actually an attorney standing next to him over at the jail right now on the screen.
Okay. So, from my understanding, the public defender told me that there will be a extradition court hearing?
Right, and the other state will have to let Broward know about that, when and how and if they want to do that.
The only other thing I would add, Judge, and I know he's got the no bond extradition hold, but Mr. Ware is one of 3 co-defendants on this morning's docket involved in the stopped car where cocaine was found in the rear passenger floorboard. All of them have been charged with possession of cocaine with intent to deliver. Mr. Ware is the driver of the car, so the cocaine was not apparently even within his reach. So I would ask the court to take that into consideration when setting bond. In fact, I would submit to the court that there can't be probable cause for everybody to have been in possession of this cocaine. Maybe the person who was sitting right in front of it, who was, I believe, a female who's on this morning's docket, but as far as Mr. Ware is concerned, they, like I say, they charge everybody in the car with the possession of cocaine that was in one location, not centrally located.
I am aware of that. I do find probable cause as to count one, and the bond at this time is $2,500. Good luck. Igor's Jutins, page 26. He has a private attorney in the courtroom, right? Ma'am, you're his attorney?
Yes, Your Honor. My name is Alma Maria Hoffenden on behalf of the defendant.
Okay, all right. Mr. Jutins, on page 26, is before the court today, sir, you're before the court today for one count of aggravated battery, and the court does find probable cause, as the parties wish to be heard as to bond.
Yes, Your Honor, the state is asking for 25,000 bond with pretrial with a GPS monitor, Your Honor.
Ma'am?
Yes, Your Honor. My client is not a flight risk. He has significant ties to the community. He does not have any convictions. He has been working as a successful a broker and a real estate agent for 15 years. He has been married for 10 years, and he's a father to 5 children. He has been living in Florida for the past 10 years, and he's not a flight risk, I assure you, Your Honor. And also, he will be asking for a bond between $10,000 to $15,000.
Mr. Igor, I believe she said 25. I apologize,
Okay, the court does find probable cause. At this time, I am going to impose a bond of $25,000 and also with a GPS. Thank you, ma'am.
Thank you, Your Honor.
I'm sorry, also ask for no victim contact.
And I was looking for the name, but no contact with the victim in this case.
Thank you.
Okay. All right, and then the last one for now that I'm going to call out of order. And then I'll, Colin McLean on page 13.
Page.
All right, Judge.
I read lips.
Colin McLean on page 13. Good morning, Mr. McLean. Sir, you're before the court today for 2 counts of sexual assault.
We'd waive formal reading, Judge.
All right. The court does find probable cause.
Your Honor, the state is based on, and Detective Edwards is present before the court. I'm not going to be eliciting any testimony from her this morning, Your Honor. I believe the probable cause affidavit speaks for itself. I am going to be seeking finding a proof evident or presumption great on these 2 counts for first appearance purposes only, seeking a no bond hold, and additionally an order of no victim contact with J.M.
In light of the fact that Mr. McLean currently has a no bond hold on count one, we would be deferring any argument regarding proof evident presumption great until such time as Mr. McLean can appear in front of his division judge. Mr. McLean is also invoking his Fifth Amendment right to remain silent at this time. I'm advising the state attorney's office and the detective who's here and all law enforcement they're not to contact Mr. McLean without first contacting his attorney. Mr. McLean, I'm advising you not to discuss this case with anyone. That includes conversations on the phone. They are listening to your phone conversations. They are being recorded, and they will be used against you if you make any incriminating statements. Do you understand that you are not to discuss this case with anyone but your attorney? I didn't hear you.
You need to
I
turn
think
the microphone
You
on.
need to turn the microphone on there, Mr. McLean. Hit that button right in front of you. Still can't hear you.
Speaker on.
Okay?
I understand.
Okay, now we can hear you. Okay.
Okay, Mr. McLean, as stated before, you have 2 counts pending before this court. I do find probable cause as to both counts after reviewing the probable cause affidavit. I also find that proof of guilt to be evident, and therefore you will be held without bond until further order of the court. This order is without prejudice for you and your attorney to file a motion to set bond in your assigned division and request a hearing under State v. Arthur. There shall be no contact with the minor victim with the initials JM. Good luck, sir.
What's that? I'm sure you gave this many times. There's a faster way to go through this.
All right, I'm gonna go back to my regular order. Michelle,
Our Spanish interpreter is
I'm
present,
sorry.
Judge.
Who's the interpreter here for? Thank you.
On page 25, Jose
That is correct,
Sanchez
Mr.
Medina.
Sanchez, Jose Sanchez, and I believe he has a private counsel.
Yes, he does.
Mr. Mark Z, who I believe I just saw walking around.
Yes.
Was here.
Oh, he's not here now. Is there anyone else that needs a Spanish interpreter?
I believe that's it, but I will inquire again. Alguien que solamente habla español. You're Sanchez. Sí, no. Parte de ti. Solamente habla español. Just that one gentleman here at Maine, Judge. I don't know if the other facilities.
Just one moment. I need to find it.
Page 25 towards the latter part of your stack, Judge.
Is that
Sanchez Medina.
Jose Alexander Dre Sanchez Medina?
Correct,
Yes,
Your Honor.
Judge.
Okay.
Mark Z on his behalf.
Good morning, Mr. Z.
Good morning, Your Honor. Jose, your family
oh,
asked
wait,
me to come here for you. He doesn't know that I was even here, Judge.
Okay, one moment. Sir, do you swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do, Your Honor. For the record, that's Igor Feliciani.
Good morning, Mr. Feliciani.
Good morning, Your Honor.
Mr. Sanchez Medina, good morning.
Señor Sánchez Medina, buenos días.
Buenos días.
Good morning.
Sir, you're before the court today for 1 count of touch or strike battery and 2 false imprisonment of an adult.
Señor Sánchez Medina, usted se encuentra hoy frente a la corte por un cargo de contacto o impacto físico y por otro cargo de privación ilegítima de libertad de un adulto.
The court does find probable cause.
La corte halla que hay causa probable.
The parties wish to be heard as to bond.
Yes, Your Honor, if I may.
Se le pregunta al abogado del señor Medina si quiere ser escuchado acerca del asunto de la fianza. Sí, su señoría.
Mr. Sanchez Medina, in my opinion, I think has no prior history. He's married, he has 2 children, he is the sole provider for his family, he resides in Homestead. Forget it.
El
You're gonna have
señor
to,
Sánchez Medina, creo que no tiene antecedentes, está casado, tiene 2 hijos, es el único proveedor de esta familia.
Sole provider for his family, 2 children. Because he lives in Homestead, he is not a citizen, he is here on political asylum, he is legally working on a visa. In my opinion, oh no, he was telling me to keep going.
Oh, really? I'm sorry. Ok, él vive en Homestead, él no es un ciudadano, pero está aquí en asilo político, está trabajando legalmente para obtener una visa.
I've spoken with his family, they're hiring me, Your Honor, he is not a flight risk. I've read the probable cause affidavit, Mr. Sanchez obviously has a different version of events. But based on that, I would ask the court to set a low bond, he does not have substantial financial needs.
Yo hablé con la familia del señor Sánchez, ellos me van a contratar, yo leí la declaración jurada de causa probable, el señor Sánchez obviamente tiene una versión diferente de los eventos, por tanto en estos momentos estamos solicitando que se fije una fianza baja, visto que el señor Sánchez no es una persona de grandes recursos.
I just ask the court to keep the monetary bond low as possible. There's no issue with pretrial release. I would ask that it not be electronically monitored for what purposes that would be difficult for him. But I would ask that the court keep the bond low as possible on monetary purposes. He does not have a lot of money.
Le pediría nuevamente a la Corte que mantenga la fianza baja. Le pediría a la Corte que omitiera un monitor electrónico para efectos de su trabajo. Él no es una persona que haya riesgo de que se escape. Y nuevamente le pediría que mantuviera la fianza en un monto razonable. Your Honor, I'm going to be requesting a $15,000 bond on count 2 and an order of no victim contact. Su señoría, la Fiscalía va a pedir una fianza de $15,000 por el cargo número 2 y una orden de no contacto con la víctima. I do have a concern based on the allegations, and I would also note the specificity of the allegations provided by the alleged victim. La Fiscalía tiene preocupaciones acerca de la naturaleza de los alegatos, específicamente por la especificidad de los alegatos presentados por la supuesta víctima.
is that it? Okay,
Más nada de la Fiscalía.
Judge, nothing further. His family would be here, but they couldn't get here from Homestead in time.
okay. All right, the court does find probable cause, as to count 1, touch or strike battery. The bond will be set at $5,000. As to count 2, false imprisonment, the bond is $10,000.
La Corte ha leído la causa probable y decidió fijar la fianza en el cargo número 1 de contacto o impacto físico en $5,000 y el cargo número 2 de privación ilegítima de libertad en $10,000.
And Mr. Sanchez Medina shall have no contact with the alleged victim in this case.
Y el señor Sánchez Medina no podrá tener contacto con la supuesta víctima en este caso.
Good luck, sir. Thank you.
Buena suerte a usted, señor. Su abogado permanecerá en contacto con su familia para pagar la fianza para sacarlo, ¿ok?
Is there anyone else at any of the other facilities that need a Spanish interpreter? Spanish interpreter?
No one at Main, Judge.
All right. Good. Thank you, sir.
No Paul Ryan, no.
No Paul Ryan.
Okay. County.
They can all hear me.
Okay. Have a good weekend, Your Honor.
Okay, you too. Thank you.
Oh, bro, don't need.
Okay. All right. This is Pompano. All right, now Tuesday Marie Davidson.
I believe North
Davidson is
Broward,
North
Judge.
Broward Judge. Should like to resolve this matter if possible today.
Ms. Davidson, good morning.
Good morning.
Ma'am, you're before the court for one count of trespassing.
Yes.
The court does find probable cause, and I'm told that you wish to resolve your case today. Is that correct?
Yes, ma'am.
State.
Time served, no return, Judge.
All right, Ms. Davidson, if you wish to resolve your case, the sentence is adjudication, time served. Do you wish to resolve your case with that plea?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Ms. Davidson, do you understand the proceedings that you're in today?
Yes.
Do you need more time to speak with your attorney?
No.
Do you understand that by taking a plea today, you're giving up your right to trial?
Yes.
Have you ever been treated for mental or emotional illness?
No.
Are you under the influence of drugs or alcohol?
No, I take medication for a fractured leg from when I got hit by a car, but that's just approximate.
Is that affecting your decision-making today?
No, I ain't on it right now. I'm just saying that's what I take up. I got hit by a car in December.
Okay, do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
What plea do you wish to enter, Ms. Davidson?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence is adjudication and time served. And ma'am, no return to Saxon Wall
Yes.
convenience.
I know where it's.
Okay, do not go back there. Thank you.
I won't. Thank you.
All right.
Your Honor, did you pass over Miss Michelle Marino?
Maybe I did. Michelle Marino?
North Broward, it's a municipal ordinance case.
Yes.
Right, but I think I passed it over because we're waiting for Mr. Shate. Is this?
I don't think he's going to be here this morning, Judge, according to
Oh,
what he
that's what
told
you
me.
said.
Yes.
Oh, I forgot. All right, Michelle Marino. Ma'am, you're before the court today for 2 counts of municipal ordinance. And the court does find probable cause. Ms. Marino, what do you wish to do today?
I want to settle this case, please.
All right, Ms. Marina, you are entitled to an attorney. Your attorney's not here today, so I know that you've already indicated you want to settle your case, but the options are to settle the case or to wait for your attorney to be here.
No, I don't have an attorney.
Okay. Ma'am, then if you wish to resolve your case today, I'm going to do adjudication and time served. Do you wish to take that plea offer?
Yes.
Then, ma'am, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand the proceedings that you're in today?
Yes.
Do you need more time to speak with your attorney?
No.
Are you under the influence of alcohol or drugs?
No.
Is anyone forcing you to resolve your case today?
No.
Do you understand that you do have the right to an attorney and a right to trial, that by taking a plea today, you're giving up those rights?
Yes.
Are you under the influence of alcohol or drugs?
No.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration
Yes.
changes? What plea do you wish to enter, Ms. Marino?
No contest.
I accept your no contest plea, and I find that it's freely and voluntarily given. Your sentence will be adjudication and time served. Ma'am, I'll give you 6 months to pay your court costs. Good luck.
Thank you.
And Sarah Jameson.
North Broward municipal ordinance.
Ms. Jameson, good morning. You're before the court also for 2 municipal ordinance violations. Ma'am, you are entitled to an attorney. Your attorney's not here today. I can reset your case.
No, it's okay.
Or you can resolve it with an adjudication and time served. Do you wish to do that?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand the proceedings that you're in today?
Yes.
Is anyone forcing you to resolve your case today?
No.
Do you understand that you have a right to go to trial and that by taking a plea today, you're giving up that right?
Yes.
Are you under the influence of any alcohol or drugs?
No.
Have you ever been treated for mental or emotional illness?
No.
Do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Okay.
All right. What plea do you wish to enter?
No, no contest?
Then I accept your no contest plea and I find that it's freely and voluntarily given. Your sentence is adjudication and time served. Good luck, ma'am.
Thank you.
You're welcome. 6 months to pay the court costs. Barbara Danner.
Medical reset, Your Honor.
All right. Alexandra Dominique. Alexandra Dominique.
North Broward. She refused, Your Honor.
Well, what did, Mr. Reedy, does the PD represent Ms. Dominique?
Alexander Dominique, she's
Refused.
This is is it a medical reset? It was a medical reset last time or yesterday, I
just
think.
heard someone say she
I'm a neighbor.
Yes.
so I don't know.
It's a medical reset or is it a refusal?
She refused, Your Honor.
We do represent her.
All right,
We sent an interviewer out actually to see her today.
okay. So do you want me to reset this for tomorrow?
Yes, please.
Okay. All right. Brittany Deslandes.
She's approaching, Judge. She's here at Maine.
Ms. Deslandes, good morning.
Good morning.
Ma'am, you're before the court today for one count of felony battery, and I do find probable cause as the parties wish to be heard as to bond.
Your Honor, Your Honor, I'm going to be requesting a bond in the amount of $7,500. Just noting the level of violence, the injuries suffered by the alleged victim. Ms. Deslandes has a lengthy juvenile history, some of it involving violence. And from what I'm showing right now, she is on conditional release in several juvenile matters. I'd also be asking for an order of no victim contact.
Judge, $7,500 is going to be a little bit out of reach for Ms. Deslandes. She's 18 years old, been residing in our community her whole entire life. This is her first felony adult charge, and she's pretty right now about this incident. Now, I didn't have an opportunity to review the PC affidavit, but I believe there's probably two sides to this story. and that's for a later date. Having said that, Judge, right now she is currently going to school. She's attending Broward College. She wants to study nursing. She goes 3 days a week on Tuesday, Thursdays, and Mondays. On Monday, she goes from 12 to 6. On Tuesday, she goes 9 a.m. to 3 p.m. And on Thursday, she goes from 2 to 7 p.m. Judge, she is a foster child. She has benefits such as housing and education. Right now, my understanding is the alleged victim was a person that she was residing with. My understanding is that through, I believe, the department, they've set up an alternate residential location where she's going to be residing in Hallandale. So I did advise her. Most of the time, the court is going to impose a no contact order. She has no problems adhering to that no contact order. She will not have any sort of contact, direct or indirect. She does have a sister that's she's going to be reaching out to post her monetary bond. She does not believe her sister does have much monetary funds disposable. So I'm going to be asking Judge on this third-degree felony, $1,000 bond on her behalf.
And I just want the court to be aware, I'm showing on at least 10 occasions in the past as a juvenile, pickup orders were issued either for a failure to appear or because she absconded.
The court does find probable cause, and at this time, I will impose a bond of $2,500. I'm also, Mr. Slanders, no contact with Triuna Key in this matter, and it's just one, Triuna Key. Good luck, ma'am.
Judge, can I have a photo order, please?
Sure, I'll sign. All right, Mr. McLawrence, I believe you have two matters here. Stephen Crowley on page 7. Mr. Crowley, good morning. Sir, you're before the court. It's a misdemeanor capias on a alcohol beverage violation. You failed to go to court. What does Mr. Crowley want to do, Mr.?
That you would like to resolve.
Mr. Crowley, if you wish to resolve your case today, alcoholic beverage, it'll be withholding court costs. Do you want to resolve your case with that plea?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
Okay, you can put your hand down. Mr. Crowley, do you understand the proceedings that you're in today?
Yes, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that by taking a plea, if you're not a U.S. citizen, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, what plea do you wish to enter, Mr. Crowley?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. I sentence you to withhold adjudication and court costs. Does you need more time to pay this cost, court costs?
Then more than 6 months, Judge?
6 months?
No, I think that's fine.
Okay.
Take care, Mr. Crowley. Remember what I told you about Wednesdays.
All right.
And Shanard Neely on page 8. Shanard Neely?
Yes, ma'am.
Mr. Neely, you're before the court today for a misdemeanor capias matter.
How many?
It's a municipal ordinance. It's trespassing. What does Mr. Neely wish to do?
Judge, after discussing the matter with Mr. Neely, he would like to resolve.
Mr. Neely surrendered himself. All right, I'll be a withholding court costs. Mr. Neely, do you want to resolve your case with that plea?
Yeah, I do.
All right, sir, please raise your right hand. Do you swear affirm to tell the truth?
I do.
Okay, you can put your hand down. Do you understand the proceedings you're in today, sir?
Excuse me, say that again.
Do you understand the proceedings you are in today?
Yeah, I do.
And do you need more time to speak with your attorney?
Nah, I'm good.
And do you understand that you do have the right to go to trial, so that by taking a plea today, you're giving up that right?
Right.
It's yes or no. Do you understand?
I do.
And are you under the influence of alcohol or drugs today?
No.
Have you ever been treated for a mental or emotional illness?
Emotional illness, yeah. Prozac. Have I been treated? Yeah.
Okay. Are you taking medications today that would affect your decision making?
No. No.
And do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes? All right. What plea do you wish to enter, Mr. Neely?
No contest.
Sir, I accept your no contest plea and I find it's freely and voluntarily given. I sentence you to a withhold adjudication and court costs. I'll give you 6 months to pay your court costs. Good luck, sir.
What was my sentence you said?
Withhold $78 in court costs. Remember about Wednesday, Mr. Neely.
All right. There is, all right, on page 20, there is Cedral Russell. Someone signed in for Mr. Russell. I'm sorry?
I've been advised Mr. Russell is a medical reset on
All
page
right.
20.
Okay. Sir, good morning. Thank you for being here, but Mr. Russell will be reset for medical purposes. So he won't be here today, so we won't address his case today. Okay? Well, they normally reset it for 24 hours, so, but, I don't know what the situation is. So it's, at this point in time, 24 hours.
Actually, first of all, I have 4 strokes myself. I take care of 2 heart attacks and paper and cancer. But I take care of my brother. But I'll be here tomorrow. What? Same time, same place. I'll be here tomorrow.
Okay, sir. Good luck.
Thank you, sir.
Okay. Jennifer Cremades.
She's approaching Judge. She's here at Maine.
Good morning, ma'am. You're before the court today for one count of neglecting child without great bodily harm. And the court does find probable cause. Does the parties wish to be heard as to bond?
Your Honor, at this time, I'm going to be requesting a $5,000 bond in an order of no victim contact. I would note Ms. Cremades is currently out on bond for a pending battery before Judge Solomon. I would also note her other priors: 07 prostitution, 05 strong arm robbery.
Mr. Romero?
Judge, at this time, nothing to defense, Judge.
Okay. Ms. Cremades, the court does find probable cause, and your bond, your release conditions will be as follows. $5,000 bond, there will be a level 2 GPS, no victim contact. Good luck, ma'am. Sharnay Irisha Clifton.
Paul Ryan.
Ms. Clifton, good morning.
Good morning.
Ma'am, you're before the court for 1 count of grand theft auto, 2, resisting officer without violence, and 3, driving while license suspended without knowledge. Count 3 is not for magistrate. I do find probable cause as to counts 1 and 2, as the parties wish to be heard.
Can you afford a $1,000 bond, Ms. Clifton?
What was the question?
Can you make a $1,000 bond?
Yes.
And we have nothing further to say, Judge. You're sure about that, Ms. Clifton?
You said 1,000, right?
Yes.
Yes.
Okay. Then, Judge, I'd ask you to leave the bonds in place.
Okay, Ms. Clifton, I do find probable cause. Your bond on count 1 is $1,000. Resisting without, bond is not required. I will not impose a bond. Good luck, ma'am.
Thank you.
All right, Carrion Veazey.
Put this on recall, Judge. I need to speak to Mr. Veazey.
Okay, Ms. Veazey, your attorney wants to speak with you. Can we do Ashley Nicole Lloyd?
She's approaching, Judge. She's here at me. Come on up, ma'am.
Good morning, Ms. Lloyd. You're before the court today for 1 count of felony violation of probation. There is also an out-of-county hold, which is not for magistrate. So everything remains the same. They're both no bond holds. Good luck, ma'am. How about Clarissa Jones?
Self brought, Your Honor. She's also a refusal.
Well, this is the 3rd time, or was it medical reset before?
It's been a medical reset, however many times. This is the first.
We did I found probable cause before, and she needs to come before the court for a setting of her bond.
She violated probation. State prison. Yeah, but it says it went to her February 8th. From February 8th. Okay, I'm gonna go to Walmart.
How about Elizabeth Buckley? She's also a medical reset, or was a medical reset. Elizabeth Buckley? Do we know where Elizabeth Buckley is?
I'll check to see what jail judge.
Paul Ryan, Judge, I believe.
Thank you. Miss Buckley? You have to turn your mic on. All right, Miss Buckley, you're before the court today for 1, grand theft auto, and 2, possession of drug paraphernalia. Is Miss Buckley, the court does find probable cause. Is Miss Buckley represented by the Public Defender's Office? All right, Ms. Buckley, as to count 1, your bond is $1,000, and there'll be no bond imposed on 2. Good luck, ma'am. Mr. Reedy, on Clarissa Jones, she's been a medical reset 2 or 3 times. We did find probable cause. Do we know what the status is? Right. All right, then it'll be on a reset. Maybe someone can go out and speak with her to find out what the situation is. Okay, thank you. Alton Harris. Alton Harris?
I thought that was the gentleman that was gonna. For Judge.
Conti.
The name does sound
Oh, is this
familiar,
in that
but
church? Oh.
Alton Harris?
Conti.
Mr. Harris, you're before the court today. It's a misdemeanor capias on a municipal ordinance matter. For yes. Right.
Yesterday,
Right.
and he RR'd him on the other misdemeanor cases.
Okay.
Then this case was issued when he was being released.
All right. So can we? Oh, it's Judge Pohl. So I will ROR Mr. Harris on this matter as well. Good luck, sir. Kamani Jarrett.
North Broward, Your Honor.
North Broward. Mr. Jarrett, good morning. You're before the court today for 1 count of petty theft and 2 resisting officer without violence. I've been told by confinement status that your bond has been posted. And sir, while this case is pending, I'm also going to tell you not to return to Walmart.
Okay.
In Hollywood. On 301 South State Road 7, no return to Walmart. Good luck, sir. All right.
We could recall.
If we can recall whom?
Miss Vacy on page 5.
Okay.
She's in North Broward.
All right, Miss Vacy.
I'm sorry, she's in Paul Ryan, Judge.
Good morning, Miss Vacy.
Judge, I'm gonna ask the court to consider releasing Miss Vacy on her own recognizance. This is one of the cases, we had one of the co-defendants earlier where there's the cocaine found in the car. As I understand it, it's actually underneath the driver's seat, and Ms. Vasey was unaware of its presence, which, as I say, they charged everybody in the car with possession of the same amount of cocaine. And it's not her car. She was not driving the car. She's lived here all of her life. She lives with her mom. She's been living with her mother for 6 years now. And I'd ask the court to consider releasing her on her own recognizance. I don't think she's going to be able to make any kind of a monetary bond.
Your Honor, it wasn't, and I know the court's familiar because you read it. The drugs were not found under the driver's seat. They were found exactly where Ms. Vesey was sitting.
Well, that's what they say.
Well, that's what we have to go by.
But that may not actually be the truth.
We'll have to get worked out at a later date.
All right. I do find probable cause, and the bond will be $2,500. Good luck, Ms. Vasey.
And I left a message for Ashley. I'll try her again.
Jacob Kozorok.
Is approaching Judge Municipal in Champaign.
Good morning, sir.
How you doing today?
I'm doing well. You are before the court today for a municipal ordinance matter to trespassing. Sir, you're entitled to an attorney. Your attorney's not here today, or the attorney for the city of Pompano. You have two options. You can resolve your case today, or we can reset it for your attorney to be here this afternoon.
Okay, if I resolve, I'm not gonna lie, it takes to be resolved. I'll resolve. I'm served, I don't know how to work.
Okay.
I just wanna go.
All right, sir, if you want to resolve your case today, it'll be an adjudication and time served.
Yes, fine.
All right, raise your right hand, please.
Yes.
Do you swear or affirm to tell the truth?
Yep.
Put your hand down, sir. Do you understand the proceedings that you're in today?
Yes.
Do you need more time to speak with your attorney?
Negative.
Is anyone forcing you to resolve your case?
Nope.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Sure do.
And do you understand that you do have the right to go to trial, that by taking a plea, you're giving up that right?
Correct.
What plea do you wish to enter?
No contest.
I accept your no contest plea. Find that it's freely and voluntarily given and sentence you to adjudication and time served. And I'll give you 6 months to pay your court costs, sir. Good luck.
Thank you very much.
You're welcome. Jason Fisher.
Mr. Fisher's approaching Judge, another municipal.
Mr. Fish, yes. All right, Mr. Fisher, instead of, you're gonna be brought back this afternoon, so we'll handle your cases this afternoon. There's,
Why like to be brought?
Juan Flores.
Mr.
Juan Flores, North Broward.
He's a refusal, Your Honor.
All right,
So we have one reset.
all right, Mr. Flores, you'll be reset. Taurus Horn.
He's approaching Judge.
Good morning, Your Honor.
Good morning, sir. You're before the court today for on two counts of touch or strike battery, and I do find probable cause. Does the parties wish to be heard as to the bond?
Your Honor, I'm asking that the court keep the standard bonds in place, issue an order of no victim contact with Maria Tapiero Valera. Mr. Horn's criminal history, 2018, loitering and prowling, 2016, possession of PVP, 2015, robbery with a weapon and aggravated battery with a deadly weapon, 2015, possession of PVP, 2015 possession of PvP. He's got multiple priors before that, and also just noting an aggravating factor in this matter is that the alleged victim was holding her 2-year-old while the batteries allegedly occurred.
Mr. Romero?
Yes, Judge, I understand the allegations are serious, but Mr. Horn is denying those allegations. Having said that, Judge is 36 years old, been here his whole entire life. Right now, he's not working, going to Sheridan Tech. He enrolled in their HVAC program. Right now, his family is not going to be able to afford to post his monetary bond. My understanding, his mother was affected by the government shutdown. She was a federal worker, and right now, because she's so backed up on bills and things like that, she can't afford to possibly post any sort of monetary bond. Mr. Horn is a father. He has 2 children, a 3-year-old and a 6-year-old, and the 3-year-old's birthday is actually tomorrow. Judge, he wants to be out there for his children, but he can't afford to post a monetary bond. Now, he will adhere to the court's order as far as no contact, but he just cannot afford a monetary bond, so he's asking the court to consider releasing him on pretrial release.
All right, that will be denied. Mr. Horn's bonds will be $1,000 on each count, no contact with Maria Tapiero. Good luck, sir. Willie Randall.
Judge, Mr. Horn wishes to address the court.
Yes.
Ms. Powell, good morning.
Good morning.
Right now, like I said, like I told Mr. Romero, due to the government shutdown, our family is in transition right now. We just actually lost this place. I've been there 17 years. We just lost this place Sunday. Upon this incident happening, I was retrieving property from my property. Okay, but I was retrieving property. I have no problem making no contact with the victim because I was not going to be there anyway. So right now, like I said, I have 2 young children that I help watch. My fiance works nights at security for Allied Universal. Is anything or something? I mean,
Sir, what kind of work do you do?
I'm a stay-at-home father.
Okay.
I actually had an interview yesterday for a financial company. Usually I work, I'm a restaurant cook by trade. I have over 5 years experience. Right now I'm trying to try something different with the HVAC program. Right now with the government shutdown, I've been trying to look for employment, aside going to school and keeping my kids.
Well,
so
that the bond is going to remain at the $2,000, $1,000 each count. Good luck, sir. Willie Randall. Mr.
Randall's here, present, Judge Municipal.
Mr. Randall, you're before the court for municipal ordinance. It's for alcoholic beverage. Mr. Randall, this is the city of Pompano Beach, and the attorney's not going to be here today, so you can either resolve your case or I can reset it for the attorney to be here.
I'll resolve it.
All right, sir. If you wish to resolve your case, then the offer will be a withhold adjudication and court costs. Do you wish to do that, sir?
Yes.
Please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Do you understand the proceedings that you're in today?
Yes.
Is anyone forcing you to resolve your case today?
No, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Sir, do you understand that you do have the right to go to trial, that by taking a plea today, you're giving up that right?
Yes.
Sir, have you ever been treated for mental or emotional illness?
No, ma'am.
And do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to immigration changes?
Yes.
All right. What plea do you wish to enter, Mr. Randall?
No contest.
Sir, I accept your no contest plea. I find that it's freely and voluntarily given. and I sentence you to a withhold adjudication and court costs. I'll give you 6 months to pay your court costs, sir. Good luck.
Thank you.
Michael Cade,
Oh, yeah. Yes, ma'am, that's me. Honesty. Thank you. Thank you.
Mr. Cade was,
Yes, ma'am.
Mr. Cade, you're before the court today for municipal ordinance matter 2 counts. Mr. Cade, do you want to, I can reset you for the afternoon if you wish, so that you'll have an attorney.
Nah, I wish to resolve.
Sir, if you resolve your case today, your sentence is going to be adjudication and 5 days in the Broward County Jail.
5 fucking days. Okay.
All right. You sure that's what you want to do?
Yeah, and I didn't know smoking at a gas station was, that expensive.
All right. Well, please raise your right hand, sir.
Okay.
Do you swear or affirm to tell the truth? You've got to give a verbal response. Otherwise, I'm just going to reset the case.
I said, yeah.
I didn't hear you before. You
Can you hear me?
Okay, no, you don't.
Yes.
No. You don't need to do that. You just need to speak. All right. You can put your hand down. Do you understand the proceedings that you're in today?
Yes.
And is anyone forcing you to resolve your case today?
No, ma'am.
Do you need more time to speak with an attorney?
No, ma'am.
What will be your sentence? What did I tell you that your sentence would be today, sir?
5 days in adjudication, ma'am.
Okay. All right. Do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Right.
Have you ever been treated for mental or emotional illness?
No, PTSD.
Okay. Are you taking any drugs or alcohol today that would affect your decision making?
No.
What plea do you wish to enter, Mr. Cade? Guilty or no contest?
No, innocent. No contest.
Okay, I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, will be adjudication and 5 days in the Broward County Jail. Credit for any time served. Good luck, sir.
Right.
Gary Altman. Mr. Altman, you're before the court today for 2 counts of municipal ordinance. I do find probable cause. Mr. Altman, what do you wish to do today? We can reset you.
Resolved right now.
All right, sir. Sir, if you wish to resolve your case, your sentence will be adjudication and time served. Is that what you wish to do?
Yes, ma'am.
All right, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down. Mr. K, do you understand the proceedings that you're in today?
Yes, ma'am.
Do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No.
Have you ever been treated for a mental or emotional illness?
No.
Do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes, ma'am.
Is anyone forcing you, Mr. Altman, to take a plea today?
No.
All right, sir. What plea do you wish to enter?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, is adjudication and time served. I will give you 6 months to pay your court costs. Good luck.
Thank you.
Bernard Malone. Mr. Malone, you're before.
Municipal ordinance case, sorry.
Yes, Mr. Malone, you're before the court today for two municipal ordinance, counts, and the court does find probable cause. Mr. Malone, what do you wish to do with your case today? Mr. I'm sorry?
Huh?
Yes, what you want to talk Hey, hey.
Mr. Malone, you have two choices. Hello, gotta pay attention over here. We can reset your case for you to speak with an attorney, or you can resolve your case today. Okay. All right, the sentence will be adjudication and time served, if that's what you wish to do.
Yes, ma'am.
Mr. Malone, please raise your right hand. Do you swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down, sir. Do you understand the proceedings that you're in today?
Yes, ma'am.
Do you need more time to speak with an attorney?
No, ma'am.
Do you understand that you do have the right to go to trial? That by taking a plea today, you're giving up that right?
Yes.
Do you need more time to speak with an attorney?
No, ma'am.
Have you ever been treated for mental or emotional illness?
No, ma'am.
Mr. Malone, do you understand that if you're not a U.S. citizen, that by taking a plea, it could subject you to deportation or immigration changes?
Yes.
All right. What plea do you wish to enter, Mr. Malone?
No contest.
I accept your no contest plea, sir. Find that it's freely and voluntarily given, and I sentence you to adjudication and time served.
Yes, ma'am.
You will have 6 months to pay your court costs. Good luck, sir.
Thank you.
You're welcome. Tedrick Morris.
Mr. Morris, come on up, please. He's here present, Judge at Maine.
Mr. Morris, you're before the court this morning for possession of cocaine, 20 grams or less, and I do find probable cause. Do the parties wish to be heard as to bond?
I believe it's cannabis.
I'm
Your
sorry.
Honor.
I'm sorry if I said cocaine. I meant possession of cannabis, 20 grams or less.
I wanted to ask if the state has an objection on an ROR, Mr. Morris's behalf.
Probably not, but 1 minute. That's fine, Judge.
All right, then the court will ROR Mr. Morris on this count. Good luck, sir. Brett Anzalone.
Judge, I've been appointed, he bonded.
Thank you. Michael Anzalone.
He bonded as well, Judge?
Same amount.
Kendrick Raymond.
He's here present, Judge at Maine.
Mr. Raymond, good morning, sir. You're before the court for 3 counts on a misdemeanor capias. And the court does find probable cause. What does Mr. Raymond wish to do?
Judge, and speaking Mr. Raymond, on this one case number, he wishes to resolve all 3 counts today.
Does the state have an offer for Mr. Raymond?
One moment, Judge. Yes, Your Honor, I just checked. The offer I made the first time he was originally arrested was for adjudication, 5 days, county jail. The theft occurred at the location he had just recently been trespassed from. He has other priors, multiple other priors. It looks like he's got 2 days' time served now, so the offer's still adjudication 5 days.
Judge, he wishes to accept the state's offer with credit for all time served.
So I get a
Okay, Mr. Raymond, the offer is adjudication in 5 days in the Broward County Jail. Do you wish to accept that plea to resolve this case today?
Yes, ma'am.
All right, sir, please raise your right hand. Do you swear or affirm to tell the truth?
Yes.
You can put your hand down. Mr. Raymond, do you understand the proceedings that you're in today?
Yes, ma'am.
And do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case?
No.
Do you understand that you do have the right to go to trial, that by taking a plea today, you are giving up that right?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness? You gotta speak.
Oh. No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
Do you understand that by taking a plea, if you're not a U.S. citizen, it could subject you to deportation or immigration changes?
Yes, ma'am.
All right, Mr. Raymond, what plea do you wish to enter?
No content.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, will be adjudication and 5 days in the Broward County Jail with credit for any time served. Good luck, sir. David Omar Saralti. Okay.
Mr. Saralti is here, present judge at Maine.
Mr. Saralti, you're before the court today for one count of trespassing, and I do find probable cause, but I've also been informed that your bond has been posted. Good luck, sir.
Thank you, Judge.
Javante Henley.
Mr. Henley, come on up, please.
Okay. Mr. Henley, you're before the court today for one count of possession of cannabis, 20 grams or less. I do find probable cause, and I've also been advised that your bond has been posted. Good luck, sir.
Good luck, sir.
Arturo Maldonado.
He's approaching, Judge.
Mr. Maldonado, good morning.
Good morning, ma'am.
You're before the court today for one count of disorderly conduct and 2 disorderly intoxication. I do find probable cause. What does Mr. Maldonado wish to do?
Judge, in speaking with Mr. Maldonado, I did advise him that these are misdemeanor offenses. He has the right to contest. He has a $25 bond, but he wanted me to ask the court if you would consider resolving this matter today.
All right. So, do we have a plea offer from the state?
Yes, ma'am. I'm going to, hold on. Offered be time served, Your Honor, no return to this location.
All right. If Mr. Maldonado wishes to resolve his case, it's, the offer is adjudication and time served. Sir, do you wish to do that?
Yes, ma'am.
All right, please raise your right hand. You swear or affirm to tell the truth?
Yes, ma'am.
You can put your hand down, sir. Do you understand the proceedings that you're in today?
Yes, Your Honor.
Do you need more time to speak with your attorney?
No, ma'am.
Is anyone forcing you to resolve your case today?
No, ma'am.
Are you under the influence of alcohol or drugs today?
No, ma'am.
Sir, do you understand that you do have a right to go to trial and that by taking a plea today, you're giving up that right?
Yes, ma'am, right now.
Sir, do you understand that if you're not a U.S. citizen, that by taking a plea could subject you to deportation or immigration changes?
Yes, ma'am, I understand.
All right. Mr. Maldonado, what plea do you wish to enter today, guilty or no contest?
No contest.
I accept your no contest plea. I find that it's freely and voluntarily given. Your sentence, sir, will be adjudication and time served. I'll give you 6 months to pay your court costs. Good luck, sir. All right. Antonio Williams. Antonio Maurice Williams.
He's approaching, Judge. Come on up, sir.
Good morning, Mr. Williams.
Good morning, ma'am.
Sir, you're before the court today for one count of resisting officer without violence. Counts 2 and 3 are burglary of an unoccupied dwelling unarmed. Count 4 is a petty theft. Count 5, there's a violation of probation. Count 6 is a violation of probation. I do find probable cause.
Judge, since the court found probable cause at this time, nothing respect to the monetary amount on 2 and 3, because I do realize he has a VOP no bond hold. He's happy to see his division judge anyway.
Right.
But the 2 and 3 are not in custody capiases for burglaries. Mr. Williams does not know from when this stems or where. Could the court tell us the date of incident or the location?
April 12, 2016. And then there's another incident, July 22nd, 2016.
Your Honor, the state would be asking for a $15,000 bond for counts 2 and 3, based on the fact he's on probation for burglary dwelling, and he went to prison for a burglary and a battery. Burg dwelling as an habitual offender and a battery as an habitual offender. Felony battery.
And Judge, whenever the court's ready, or if the state has the information, what city, as far as the location where there's big burglaries occurred? What city?
Waterhill, April 12th, 2016.
Ariel? Oh, thank you.
July 22nd, 2016.
All right. He is on a no bond hold on counts 5 and 6. My notes indicate that he should be going to his felony division judge on February 11th. As to count 1, the bond is $100. On count 2 and 3, it'll be $2,500 each count. Count 4 will remain at $750. And then 5 and 6 is no bond hold, not for magistrate. Good luck, sir.
Judge, the last thing, I'm just gonna ask a photo order.
I'll sign it.
Thank you, Judge.
Did you say photo or phone?
Photo.
Nigel Richardson.
He's approaching, Judge.
Mr. Richardson, good morning. Sir, you're before the court today for 1 count of robbery with a firearm and possession of a weapon or ammo by a convicted felon, and using a two-way device to facilitate a felony. And I do find probable cause on all counts. Does the parties wish to be heard?
Your Honor, for count 5, the state is asking for a $10,000 bond. He has a prior robbery with a firearm, and he's I was asking for the $10,000 bond based on his priors. He is a convicted felon and was in possession of a weapon, and he was also a robbery with a firearm back in 2018. For count 4, it's held no bond. Oh, she said it was PC. Your Honor, and the state asked that we find proof evident presumption great for the no bond. On count 4.
What, is Mr. Richardson being held on some other charges? Because this is 4, 5, and 6?
He is, Your Honor. He's actually being held on the identical charges on a previous pending case on a violation of pretrial. The violation of pretrial was based on a new arrest in Dade County for burglary of a dwelling.
And those are no bond holds.
All right.
So we would be deferring any argument regarding proof evident presumption great until such time as Mr. Richardson can appear in front of his division judge to address those issues pursuant to an Arthur hearing.
All right. As to count 4, I think I said 1 before. It's 4, 5, and 6. As to count 4, robbery with a firearm, I do find probable cause. And I also find that proof of guilt is evident. He will be held no bond. That is without prejudice, for Arthur hearing to be heard in his division with his division judge. Count 2, the bond will be $10,000. And then count 5, the bond is $10,000. Count 6, it's $1,000. Good luck, sir. Christopher Falzone.
Paul Ryan, Judge, we waive formal reading of the information, of the charges.
All right, is this the one? This a change of charge?
Yes, I spoke with Mr. Reedy about this. Mr. Falzone is being held on numerous no bond holds. Bond was originally set at $25,000 on this matter with no victim contact with VS. I'm going to be requesting that the same bond be reimposed.
So the bond was $25,000?
Actually, it was 25,000 GPS level 2, no contact with minors. And the distance for the GPS was 1 mile.
Oh, I do have it, it's okay. All right, Mr. Falzone, the court does find probable cause. Your bond, sir, will be $25,000. It is the same as before, no victim contact. You also have pretrial release with a level 2 GPS and no contact with any minors. Good luck, sir. Andrew Moeller. Good morning, sir. You're before the court for it's a ad charge, felony capious, petty theft. And I do find probable cause. Your bond, sir, is $100. Good luck. John Pressure Curtis. John Curtis?
I'll get you guys from Curtis. Isn't the private counsel?
Mr. Curtis, who is your attorney?
Jonathan Friedman.
I spoke to Mr. Friedman earlier today, Judge. He has not yet been retained on this case. He did indicate that he will be seeing Mr. Curtis later today in the jail. And I made Mr. Friedman aware that Mr. Curtis has a hearing in front of Judge Usan set for Monday morning.
Okay. Yes, I do have that information. So, Mr. Curtis, the attorney has not yet been retained, but he will be coming to see you today. And you do have a hearing in front of your felony division judge on the probation violation on Monday.
All right.
Don't go anywhere yet. Stay.
I'm going to be seeking a $50,000 bond on count 1. Should Mr. Curtis post this bond or be eligible for release at some point, pretrial release with a GPS monitor, level 1, I'm also going to be requesting a TAD monitor, additional requirement, no alcohol or intoxicants, and an order of no driving. Your Honor, frankly, I consider it extremely fortunate that it appears that Mr. Curtis has never seriously hurt someone on the road, and I'm concerned that it's only a matter of time that he will. He has 5 prior DUI convictions, including the felony DUI that he's currently on probation for before Judge Usan. He actually went to prison on that case. The probation he's on now is following the prison sentence. He's been sentenced to Florida State Prison 5 times on felony DWS charges. Once on a felony DUI third or subsequent, and then the felony DUI fourth or subsequent. He's also gone to prison for leaving the scene of an accident where there was an injury. His Florida driving privileges have been permanently revoked since 2011. Your Honor, what's even more concerning, and why I think these conditions are necessary to ensure and deter Mr. Curtis from getting behind the wheel while under the influence, Mr. Freeman actually filed a motion to have his probation early terminated that was set for next Thursday. Knowing in just a week he'd be going before his judge, with quite possibly the opportunity to have his probation terminated, that wasn't enough incentive to prevent this from happening.
Judge, my understanding is that Mr. Friedman is going to be addressing all these issues. He has a no bond hold as it is. Mr. Curtis isn't going anywhere in the near future. I don't know what his financial situation is, but it doesn't really matter because he's got a no bond hold.
All right, I do find probable cause, and as to count 1, I will impose a bond of $20,000. On count 2, it'll remain at the $750. Count 3 is $100. Count 4, $100. Counts 5 and 6 are not for magistrate, and then count 7 is a no bond hold on the violation of probation. Good luck, sir.
Your Honor, as far as the state's request on the other legislations?
Don't go anywhere, Mr. Curtis. I do have, if you are able to post your bond, I am going to impose a level 1 GPS as well as a TAD monitor. Good luck, sir. Lance Simonek.
Mr. Dominic is here, present, Judge. I'm main approaching.
Mr. Simonek, you're before the court today for 1 count of premeditated murder, and the court does find probable cause. What does the parties have to say in regards to bond?
Your Honor, I'm going to be seeking a no bond hold for first, based upon a finding of proof evident or presumption great for first appearance purposes only, relying upon the arrest warrant affidavit prepared by Detective Jared Schwartz of the Margate Police Department.
Yes.
I reviewed the warrant. I think the evidence here is largely circumstantial, but in light of the nature of the charge, I'm going to defer any argument regarding proof evident presumption great until Mr. Simonek can appear in front of his division judge and address the issue there. I would also at this time be invoking Mr. Simonek's Fifth Amendment right to remain silent. I would ask that the state attorney's office and law enforcement agencies not make any effort to contact Mr. Simonek without first contacting his attorney. That invocation will be followed up in writing in the next couple of days. Mr. Simonek, I'm advising you not to discuss this case with anyone but your attorney. Do not speak on the phone about the case to anyone. They are recording your telephone conversations, and they will use whatever they record against you. Do you understand?
Yes, sir.
Okay.
Mr. Simonek, I have reviewed the probable cause and the affidavits presented to me that's been filed in this case, and I do find probable cause. I also find proof of guilt to be evident or the presumption great. Therefore, sir, you will be held without bond until further order of the court, And this order is without prejudice if your attorneys wish to file a motion to set bond on, based on State v. Arthur. Good luck, sir.
So I just like proof, evident, presumption, great for these two.
Quentin Kersey.
North Broward.
North Broward, Your Honor.
Thank you. Mr. Kersey, you're before the court today for robbery, no firearm or weapon, possession of cannabis, 20 grams or less, trespassing on occupied structure or conveyance, trespassing on occupied structure or conveyance. 5 is a violation of probation. 6, assault. 7, touch or strike battery. And 8, another violation of probation.
Judge, I do have a probable cause argument with
Okay.
regard to count 1. In reviewing the probable cause affidavit concerning this robbery charge, it does indicate that the victim was robbed by a black male, but it doesn't say how Mr. Kersey was identified as the culprit. There's only a statement here that he was later identified. It doesn't say who identified him. It doesn't say whether this was a photo lineup or a show up, or that he matched the description or was wearing similar clothing. I would argue there's not sufficient probable cause here to support a finding that Mr. Kersey is the person involved in this robbery.
That's fine, Judge. We'd ask for 24 hours. I spoke with Deputy Curro. There was an identification made. We'll just ask that it be reset tomorrow morning.
All right, that's fine.
All
We're going to
right.
bring you back tomorrow, Mr. Kersey, to
Yes,
see
sir.
if the state can, come up with some more evidence, because by
Yeah,
their own
because I don't
admission,
rob
they don't,
nobody.
they don't have
I'm
enough
sorry.
right now, okay?
All right, this will be reset till tomorrow.
All right, thank you.
All right. Cordell Thompson.
Is that Maine, Judge?
Mr. Thompson, good morning. You're before the court on 1 count of possession of drug paraphernalia. 2 is a municipal ordinance. 3, driving while license suspended.
Yes, sign 'em up.
4 and 5 are violation of probations. Court does find probable cause. As to count 1, your bond, sir, is $100. Count 2 is a municipal ordinance, so not impose a bond. Count 3, driving while license suspended, your bond will be $500. 4 and 5, you're being held no bond for felony violation of probation. And my notes indicate you should be going to your division judge on February 11th at 8:30. Good luck, sir. Joshua Jones.
Is here at Maine, Judge, and he is approaching. Come on up, Mr. Jones.
Mr. Jones, you're before the court today for grand theft. And the court does find probable cause. Does the parties wish to be heard as to bond?
Your Honor, the state would ask on top of the $1,000 bond to have Mr. Jones placed on pretrial release. He has 2 prior failure to appear, and so we would ask for pretrial.
Judge, speaking of Mr. Jones, the $1,000 bond on this grand theft is something he can't afford. He's 38, been here his whole entire life. He does landscaping, Judge. He gets paid about $80 a day when there is work. He advised me he has no money in the bank. He owns no property. He lives in Lake Worth with his cousin. Right now, he advised me that his cousin cannot post his monetary bond. So, Judge, on this non-violent offense, I'm going to be asking the court to consider releasing him on pretrial release.
He lives in Lake Worth.
Correct. He could still be on stay under pretrial release if he resides in Lake Worth, Judge. He can report by phone if the court gives him permission.
One, he's been to state prison previously out of Palm Beach, 4 separate charges of sale delivery of cocaine. He was sentenced to 2 years and a month state prison on those, showing 12 prior felony convictions, 7 prior misdemeanor convictions. If the court is inclined to release in a pretrial, we would ask that at some point, even if it's once a month, but that there be reporting in person. Just over the phone all the time, I don't believe would be adequate.
Or Judge, Your Honor could also do, and I understand what the state is saying as far as having him make contact, have him appear to pretrial upon his, court appearance. So whenever he has a court date, and for example, an arraignment or calendar call, and he has to appear, then his conditions is following his court date, he appeared before pretrial. So we'd have no objection to that condition, Judge.
All right. I'm going to deny the pretrial release. Mr. Jones, your bond is $1,000. Good luck, sir. Hippolito Urena.
He's approaching, Judge is here, man. Come on up, sir, Mr. Urena.
Good morning, Mr. Urena. You're before the court today for 1 count of driving while license suspended, and 2, there's a violation of felony probation. Your bond on count 1 is $100, and my notes indicate that on your violation of probation, you will be going to your felony division judge on February 11th at 8:30. Good luck, sir. Peter Jajowski.
North Bright, Your Honor.
Morning.
Good morning. All right, Mr. Zajowski, you're before the court today for 1 count of a possession of a weapon or ammo by a convicted felon. 2 and 3 are violation of felony probation.
May I speak?
Not about your case.
What about my probation?
No, you're gonna go to your felony division judge in regards to your probation on February
All right.
11th. Okay?
Okay, thank you.
Well, wait a minute. Don't go anywhere yet. I'm not done. As to count 1 on the possession of a weapon or ammo by a convicted felon, I'm going to impose a bond of $1,000, sir. Good luck.
Okay. All right, have a good morning.
All right, you too.
Okay.
Douglas Russell.
He's approaching, Judge, Maine.
Sir, good morning. You're before the court today for 1, a municipal ordinance violation. And 2 is a violation of probation. I do find probable cause, and as to count one, sir, your bond will remain at $25, and then on count two, you should be before your felony judge on February 11th at 8:30. Good luck, sir. Dwayne Nelson.
Nelson is here.
Mr. Nelson, you're before the court today for one count of trespassing on occupied structure or conveyance, and two is a violation of felony probation. Mr. Nelson, the court does find probable cause, and my notes indicate that on February 11th, you should be going to your felony judge, and your bond on count one for the trespassing is $25. Good luck, sir. Darrell Roach. Darrell Roach.
Mr. Roach is here, present. Judge Aman approaching. Come on up, sir.
Mr. Roach, you're before the court today for grand theft auto. The court does find probable cause. As the parties wish to be heard as to Mr. Roach's bond.
No, Your Honor.
Yes, Judge. Mr. Roach, unfortunately, he advised he can't afford to post the $1,000 bond on count one. 25 years old, been here his whole entire life. Right now, he's looking for stable employment. What he does is work off and on in landscaping. He lives in Hallandale. He's been living at the same premises for about 1 year with the roommate, and that roommate right now is kind of helping him out financially with the rent. From what he advised me, his mom lives in Homestead, but he does not believe she has the funds to post his monetary bond, so that's why we are asking for Mr. Roach to be released on standard pretrial release on this non-violent offense, Judge.
Your Honor, just so the court's aware, Mr. Roach was ROR'd January 22nd of this year on carrying concealed firearm, possession of weapon or ammunition by convicted felon. That was on a motion to release. The state is has still not made a filing decision, but obviously this would still be a violation of his release conditions on that case.
Okay. Mr. Roche, the court does find probable cause. Your bond, sir, is $1,000. Good luck. Okay, Didier Gamble.
Here, I mean.
Mr. Gamble, good morning.
Good morning.
So you're before the court today for one count of burglary of unoccupied conveyance unarmed. The court does find probable cause. Does the parties wish to be heard as to bond?
Your Honor, the state would ask for $1,500 bond.
Judge, I'm going to be asking for the court to consider an ROR on Mr. Gamble's behalf. I believe he had in record. He's 19 years old, been living here his whole entire life. He is working. He was, unfortunately, because of this incident, he's no longer working. He does have family that resides in our community. Judge, I'm just asking based on his strong ties to the community, meaning he's been here his whole entire life, and the fact that he has a clean record, Judge, I'm going to be asking the court to consider releasing him ROR. If not, this is a third-degree felony. A person in his situation with no, with a record and strong ties, then $1,000 would be what we would request, Judge.
All right, I do find probable cause, and I am going to release Mr. Gamble on standard pretrial release. Sir, you must report to pretrial supervision. Today is Friday, so I believe on Monday. And failure to report will result in your arrest. Good luck, sir. Jadel Araujo.
Judge, if I may, and speaking with Mr. Gamble, I did advise him as far as what the court was offering with a pretrial release. Judge, we're gonna, elect for the court, we're gonna ask the court not to impose pretrial and then give him a straight monetary bond of $1,000.
No, I'm gonna leave it at the pretrial release. Good luck. Jadel Araujo.
Mr. Araujo is here present, Judge.
Mr. Araujo, you're before the court today for one count of grand theft. And the court does find probable cause. Does the parties wish to be heard as to bond?
No, Your Honor, the $1,000 is what the
Okay.
state is asking for.
All right, Mr. Araujo, your bond is $1,000. Good luck, sir. Andres Rafael.
Mr. Raphael is approaching, Judge.
Sir, you're before the court today for one count of aggravated battery with a deadly weapon, 2, possession of a controlled substance without prescription, and 3, kidnapping or committing or facilitating commission of a felony.
Your Honor, the state would be seeking a no bond hold on count 3 upon finding of proof evident or presumption great for first appearance purposes only, relying upon the same, well, not the same affidavit, but same allegations against Mr. Raphael that were alleged against his co-arrestee, Natalie Williams. Your Honor, I'd be, as far as count 1, you had said $100,000 bond on her count for aggravated battery. State would be requesting the same amount. And an order of no victim contact with Roni Espinoza.
And we would be objecting to the court making a finding of proof evident presumption great at this stage of the proceedings. I reviewed the probable cause affidavit. Proof evident presumption great is the highest standard that we have in criminal law. And so I would ask the court to exercise its discretion and set a bond for Mr. Raphael, or in the alternative, make a finding that proof evident presumption great has not been met. The state has called no witnesses. They've introduced no evidence. Based on what they have presented to the court, it's the defense's position that that is insufficient for that very high legal standard. So we're asking for bond for Mr. Raphael.
Okay, the court does find that there is great concern for the safety of the community as to count 1, aggravated battery with a deadly weapon. The bond will be set at $100,000. On count 2, the bond is $1,000. As to count 3, I will find that proof is evident, and therefore, as to count 3, Mr. Raphael, you'll be held no bond. This order, sir, is without prejudice for you to file a motion to set bond based on State v. Arthur. Good luck, sir.
Saw my email about that DUI, Curtis. Oh. I'll forward it to you.
And then Joshua Aaron Grief.
He's here present, Judge, I mean.
Mr. Grief, good morning. Sir, you're before the court today for one count of robbery with a firearm, 2, aggravated battery with a deadly weapon, and 3, kidnap or committing or facilitating the commission of a felony. And the court does find probable cause. What says the state?
Your Honor, I'm going to be making the same request for no bond hold upon a finding of proof evident or presumption great on counts 1 and 3, requesting the same $100,000 bond on count 2. and no victim contact with Roni Espinoza, relying upon the previous argument I've made for his two co-arrestees that appeared before Your Honor this morning.
And I would incorporate the same objections from Mr. Grief that I made on Mr. Raphael's behalf.
Thank you. Again, the court does have great concerns for the safety of the community as to count one, robbery with a firearm. I find probable cause, and I also find the proof of guilt to be evident. And Mr. Grief will be held no bond on count one. On count two, aggravated battery with a deadly weapon, I will impose a bond of $100,000. And count three, with the kidnapping, I also find proof of guilt to be evident. You will be held no bond. And sir, this order is without prejudice to you. You will be able to, your attorney will be able to file a motion to set bond in your division based on State v. Arthur. Good luck, sir. Can we get it back? On the other one, did you write no contact with Roni Espinosa? Okay, Reynaldo Farrington.
Bonded, Judge?
Okay. Fabian Nesbitt.
He's here, I mean, Judge?
Mr. Nesbitt, you're before the court today for one count of driving while license suspended and two, failure to register your motor vehicle. The court does find probable cause.
Mr. Nesbitt is currently being supervised by pretrial services. He was placed on pretrial on January 17, 2019 by this court in grand theft, case 19-854 CF10A. Based on the court's finding of probable cause, we act as his pretrial status be revoked at this time.
All right, January 17th of this year, he was placed on pretrial?
Yes, ma'am.
All right.
And first appearance by Judge Hurley.
Okay. All right, Mr. Nesbitt, at this time, I am going to revoke your pretrial release status on case number 19-854 CF10A. I will impose a bond of $1,000, and I find probable cause on the case before me today. Your bond on count one is $750, and on the failure to register the vehicle, I will not impose another bond. Good luck, sir. Cedric Morris.
He's approaching, Judge.
Mr. Morris, you're before the court today for counts 1 and 2 are false owner info for pawning items less than $300, and counts 3 and 4 are dealing in stolen property. And the court does find probable cause. Does the parties wish to be heard as to bond?
Yes, Judge. Mr. Morris is not going to be able to afford to post the $9,000. He's 22, been here his whole life right now. He's unemployed and he's looking for work. He lost his job. He was working for a company which specializes in renovating houses, where he was making approximately about $100 a day. He lives in Coral Springs. He does have family that live in our community, but that they can afford to post a monetary bond, so that's why we're asking the court to consider releasing him on pretrial release.
Your Your Honor, the state would like to bring to the court's attention that in 2014, the defendant was charged with an armed burglary of a dwelling. He was on violation of probation. He had grand theft with a firearm, grand theft, and that's it.
Great, thank you. At this time, I will not grant pretrial release. Mr. Morris, your bonds will be as stated, $1,000, $1,000, $3,500, and $3,500. Good luck, sir.
Judge, in that case, would you consider, and I understand he has priors, but from, I believe, what the state highlighted was a couple of years ago that he picked up that new law offense. In consideration of that, and consideration that this is a nonviolent offense, and in consideration as far as financial resources, would the court consider reducing the bond on counts 3 and 4 from $3,500 each bond to $1,000 each bond? So that way he would have a total of $4,000. That's maybe something his family could strive for.
I know Mr. Romero is describing it as a nonviolent offense, but what's concerning is his prior offense is for armed burglary of a dwelling, and the stolen property in this case was taken as a result of a home burglary.
Bond reduction will be denied at this time. Thank you. Jake Heiler.
Mr. Hyler's here present, Judge.
Mr. Heiler, you're before the court today for a grand theft, and I do find probable cause, and I've been advised, sir, that your bond has been posted. Good luck, sir. Patrick D'Amico.
Mr. D'Amico, come on up.
Mr. D'Amico, you're before the court today for one count of grand theft. And the court does find probable cause. Does the parties wish to be heard as to his bond?
No, Judge.
Okay.
Did you not print out his record? All right. Judge, it's probably on paper. His criminal history, 2016, grand theft, 2.5 years state prison as a habitual offender. 2014, grand theft, VOP, 30 months habitual offender. Felony theft, 2014, VOP, 30 months. Theft, 2013, grand theft, 2012, VOP. Grand theft, 2012. Put it this way, he's got, other than that, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 other previous theft-related crimes, both felony and misdemeanor level.
All that's been. And Judge, like the state said, he does have priors, but I believe he's been 1 year clean, and therefore I wasn't asking for him to be released on pretrial or a bond reduction or an ROR. I believe what's in place right now is reasonable.
All right, I do find probable cause, and Mr. D'Amico, your bond is $1,000, and in addition, you'll be on standard pretrial release. Good luck, sir. Michael Terry. All right. Michael Terry.
Bonded.
Derek Strahan.
He's here present.
Good morning, sir. You're before the court today for 1 count of possession of cocaine and 2 possession of drug paraphernalia. I do find probable cause. Does anyone wish to be heard?
Yes, Judge. Mr. Stration, unfortunately, he can't afford to post a monetary bond, so I'll see if the state has an objection having him released on pretrial.
Pretrial is fine, Your Honor.
All right. So, I do find probable cause, sir. You will be on, released to pretrial supervision. You will also be subjected to random, drug and alcohol testing. Good luck, sir. Tabiris Brown.
Mr. Brown?
Someone just went to the restroom.
Oh, you just went to the restroom?
Someone did, I don't know.
Oh. Well, hold on one moment, Judge. Tabiris Brown on page 23. We have his card? Okay, so then that must have him. That must have been him. Judge, I believe Mr. Brown went to the restroom.
I'll recall when he's back. Charles
Thanks.
Cootie. Charles
Mr.
Cootie.
Hello, sir. Cootie. Cootie.
Mr. Cootie, you're before the court today for grand theft, first degree, grand theft. 2, grand theft. 3, fraud or money laundering transaction of 100,000 or more. 4, false ID given to a law enforcement officer. So it's grand theft in the first degree, 100,000, and grand theft, 20,000, less than 100,000, and then fraud, money laundering, laundering transaction, 100,000 or more, false ID given to law enforcement officer. Those 4 counts. I do find probable cause.
Your Honor, I'm going to be requesting bonds on the following amounts. On count 1, $100,000. On count 3, $100,000. On count 2, $50,000. I'm also going to be requesting the following release conditions. Pretrial release with a GPS monitor. That Mr. Kuti, I'm going to be requesting a Nebia requirement and full collateralization. I'm going to be requesting that Mr. Kuti surrender his passport prior to release from custody. Your Honor, in addition to the allegations in this case, I spoke with Detective Gossman of the Fort Lauderdale Police Department this morning. He is investigating this matter. I would like to advise the court, as an officer of the court, first off, he's not from here. He lives in Illinois. He's staying in a hotel while down here. He just rented a car last week. He, so far what's been confiscated from him is 2 fake passports and 2 fake visas. It's mentioned in the report that Mr. Kuti implicated himself in another fraud involving $67,500. I confirmed with Detective Gossman that Mr. Kuti admitted that he was able to successfully obtain the $67,500 in that matter. I would also note that when law enforcement took an inventory of his vehicle, and they're actually waiting on obtaining a search warrant to do a more thorough search, but Detective Gossman told me that they located approximately 15 deposit slips, 2 of which one was in the amount of $55,000, The other was in an amount of $60,000. Additionally, out of the state of Illinois, Mr. Cootie was previously convicted of aggravated identity theft against a victim over the age of 60. He was sentenced to 2.5 years probation. Let's see, one moment. Your Honor, based on the level of fraud alleged, that he has no contacts with the community, that he's gone to, I think it's reasonable to conclude that he specifically came to South Florida to commit these acts, since he doesn't reside here. He just got his rental car a week ago and is staying at a hotel. Additionally, I have concerns about his future appearance in court based on the fact that he was in possession of 2 fake passports and 2 fake IDs. Also, based on the allegations here, I've got concerns about the source of funds he would use to post bond in whatever amount the court deems appropriate. I do believe that these conditions are appropriate and necessary to ensure that Mr. Gossman appears in court in the future and also does not conduct any new criminal activity while on release.
Okay.
Judge, thank you. In speaking, Mr. Cootie, I was just going over as far as explaining him what the state is recommending. The one thing that stuck out is Mr. Cootie, there's no way his wife is going to be able to come up with the $250,000, which the state is suggesting. Now, he is from Chicago specifically. He lives in a suburb called Rogers Park. Him and his wife and his child, who's 2 years old, rent an apartment, and their monthly rent is about $1,500 a month. Now, Mr. Cootie does own a vehicle. He financed, and he pays approximately $199 a month for it. So where he's living, what he's driving, doesn't reflect the sort of, amount the state is portraying that maybe that Mr. Cootie can afford. He's down here, yes, on vacation, Judge. He does work. He's self-employed. What he does is buy things and sells things on Amazon. And from what he is saying, he gets approximately about $1,500 per week doing that. Judge, my understanding is he is a U.S. citizen. He was born here. From what he advised me, he's never applied for a United States passport, so he does not have a U.S. passport in his possession. So that condition which the state is asking the court to impose is something that he cannot fulfill. Having said that, Judge, like I said, he's going to be relying on his wife to help post his bond. We're going to be asking for the bonds that are currently set to remain, and we're going to be asking on count 3 a $2,500 bond. Also, we don't have an objection as far as having him supervised by pretrial, but we would ask for standard. If it's a monitor that's going to require him to live down here in South Florida, he's then going to have to relocate down here, find an apartment or a residence down here in South Florida, and to impose him to basically relocate down here to South Florida when he's Chicago, I do not believe that is reasonable, Judge. If he does not come down for make his future court dates, as you are aware, there'll be a warrant issued for arrest. So there are consequences of him not appearing in court. So that's what the defense is requesting for at this time, Judge.
And Your Honor, I would just note, if somebody goes to another jurisdiction and commits criminal offenses, then there are consequences to that and potential inconvenience. To say it's unreasonable, I know Mr. Romero is portraying Mr. Cootie as a family man, but Mr. Cootie's the one that left his wife and child behind in Chicago when he came down here, which the evidence would indicate, and this isn't my opinion, this is just what the evidence indicates, to come down here to commit criminal acts of stealing substantial amounts of money. I know Mr. Romero is claiming, well, he doesn't have a passport. I don't know how the court can have confidence in taking Mr. Cootie's word on anything at this point in time, based on the evidence before Your Honor.
Thank you. I have reviewed the probable cause affidavit in this case. And at this time, I do find probable cause. I am going to impose bonds as follows. On count 1, the grand theft, $100,000. Count 2, grand theft, $50,000. Count 3, fraud, money laundering, $100,000. And 4, false ID given to a law enforcement officer will remain at $100. Mr. Kuti, unless if it's determined that he doesn't have a passport, then we'll deal with it at that point in time. But at this time, the order from the court is that he will surrender his passport. There's also going to be a Nebia hold if he wishes to post the bond. And that's also going to include a level 2 GPS. Good
Your Honor,
luck.
the only other thing I'd request is that the Nebia also include a full collateralization.
Right, so that's granted.
Thank you.
James Likens,
Oh, Judge, Mr. Cootie, we would be requesting a phone order. I'm sorry about that, forgot.
I will sign that,
I may approach this.
right,
I didn't realize until after the docket started that neither you nor myself had the affidavit,
all right.
and I provided it.
Judge,
All right.
and whenever the court's ready, Mr. Brown, who is in the restroom, is back, whenever you're ready to proceed.
All right, and then what I'll do is, I'll leave Mr. Likens for last. I'll recall Mr. Likens.
Mr. Brown?
Mr. Brown,
Mr. Brown is approaching.
all right. Mr. Brown, you're before the court today for 1 count of possession with intent to sell or manufacture or deliver cocaine. Counts 2, 3, and 4 are felony violation of probation. I know that the court does find probable cause. This was the other two, with the other two.
Yes, Judge.
All right,
Yes, Judge, and I would feel remiss if I didn't renew the arguments I made for the other defendants that everybody in the car is charged with the cocaine that's somewhere in the back seat. Mr. Brown is the passenger in the car. No reason to believe that he knew or should have known that the cocaine was present. I'd argue that there's no probable cause to support count 1.
all right, so noted. The court does find probable cause, and as to count 1, Mr. Brown, your bond is $2,500. Counts 2, 3, and 4 are no bond felony holds. My notes indicate that you should be before your felony division judge on February 11th at 8:30. Good luck, sir. Fernando Medina. Mr. Medina, good morning. You're before the court today for grand theft, and the court does find probable cause. Does the parties wish to be heard as to his bond or release?
No, Your Honor.
But Judge,
Mr. Medina, your bond is $1,000. Good luck, sir. Brian Gilligan.
he's approaching. Come on up, sir.
Mr. Gilligan, you're before the court for a violation of parole. And you should be going before the parole board sometime soon for this to be heard. Good luck, sir. John Register. Is Mr. Register here today?
He's here, President Judge. Coming up, sir.
All right, Mr. Register, good morning. You're here for criminal mischief, count 1, and then count 2 is a violation of probation, and count 3 is prevent or hinder firefighter or equipment, firefighter equipment. The court does find probable cause. Your bond on count 1 is $500. Count 2 is a no bond hold, is your violation of probation. And count 3, your bond is $2,500. And my notes indicate you should be going to your felony division judge on February 11th at 8:30. Good luck, sir. Frank Amonte. Thank you. Mr. Amonte. No. Is Mr.
That's right, Your Honor.
Yes.
He refused. Frank Amonte?
Yes.
Yes, he refused.
Is Mr. Amonte represented by the Public Defender's Office? He was reset before, I don't know.
He is, Judge. He's got no bond holds.
All right, I find probable cause, and I will leave the bond at $1,000. Thank you.
Thank
How
you.
about Joe Tony? Joe Louis Tony?
Please hear present, Judge at Maine.
All right, Mr. Tony, you're before the court today. It's a change of charge. For attempted burglary and a conveyance unoccupied on both counts.
Judge, bonds were originally set at 500 per count.
Yes.
He's got probation hold, so I would just be requesting that the court set the bond, the $500 bonds back in place.
All right.
That's
So,
what the defense is requesting also, Judge.
all right, so the bonds will remain in place at $500 each count. All right. All right, I believe then the last one should be Mr. Likens, if you'll give me a few moments. Okay, I'm ready to proceed. All right, Mr. Likens? Sir, you're before the court this morning for 2 counts of sexual battery on a defendant.
Judge, we're gonna be waiving full reading of the charges.
All right, well, he's before the court today for 8 counts. And the court does find probable cause on all 8 counts. What does the parties wish to be heard?
Your Honor, I'm going to be seeking a no bond hold upon a finding of proof evident or presumption great for first appearance purposes only on counts 1 and 3. There's some other PBL offenses that Judge Orlando set bonds on, but I'm not going to be addressing those at this time. On count 6, I'm going to be requesting that the court set a bond at $25,000, identical to the other bonds that Judge Orlando set on the other counts. I'll be requesting an order of no contact with RP. And I would also just note, Your Honor, I provided the court and defense counsel with a copy of information that, not in custody information that's been filed in this case. As you can note, law enforcement didn't immediately execute the arrest warrant, so they submitted the reports to the state. While that was going on, the state investigated the matter and made a filing determination. At a later date, the state will correct the situation that there's going to end up being 2 case numbers, but I just wanted the court to be aware that the state has investigated this matter and made a determination that it was appropriate to file formal charges.
Well, that determination falls short of the standard the state is held to when asking the court to make a finding of proof evident presumption great. I've reviewed the information and I've reviewed the arrest affidavit that was provided by the state. It does appear as though many of these incidents are remote in time. I would ask the court not to make a finding of proof evident presumption great at this point and set bond for Mr. Likens, proof evident presumption great being the highest standard of proof that we have in the criminal justice system. The state's called no witnesses, introduced no evidence, only merely an affidavit and an information, neither of which is substantial enough to rise to the level of proof evident presumption great. So I would ask the court to set bond for Mr. Likens in these charges. Any of the conditions that the court wishes to impose as a condition of bond, we would not object to.
Your Honor, one, I would just, and I think the court knows, I wasn't arguing that the court should consider the information as a basis to find proof evident or presumption great. I'm relying upon the affidavit, Your Honor. These are really not remote in time, considering allegedly the most recent incident was December of last year. I would also note that there is a controlled call where an excerpt from the controlled call is listed in the affidavit where Mr. Likens confessed to the actions committed against the victim in this case.
I have reviewed the probable cause and the affidavits provided to me, and I do find probable cause. And as to counts 1 and 3, I also am going to find that proof of guilt is evident. And as to counts 1 and 3, there'll be a no bond hold. As to counts 2, 4, 5, 6, 7, and 8, the bonds will be $25,000. Sir, you'll have no contact with the minor victim whose initials are RP. And on your no bond holds, it is without prejudice. Your attorneys will have an opportunity, if they so wish, to request a hearing based on State v. Arthur. Good luck, sir.
Got it right here. As soon as we're done with this case. Sheila.
All right, I believe that brings us to the end of our docket. Thank you, everyone.